From the reliefs as claimed, it is apparent that the challenges raised was to the allotments made in favor of the fifth and sixth respondent only. We are constrained to note this on account of the fact that Sri Oza had, in the course of his oral submissions, contended that not just the allotments made in favor of the fifth and sixth respondent, but also various other allotments had been made in violation of the policy of the corporation and in any view of the matter in breach of the mandate of Article 14. However, no details of these alleged allotments were disclosed either in the writ petition or in the subsequent rejoinder affidavit which was filed on behalf of the petitioner. It is in the above backdrop that we now proceed to note the rival contentions. Para. The petitioner sought the issuance of directions commanding the corporation to produce the relevant records in respect of the transactions which mentioned stood made in the writ petition. In the writ petition, it was averred that the allotments of large tracts of land was being made in utter violation of the principle which must inform a decision of instrumentality of the state which proceeds to distribute. These allegations, as noted above, were primarily made in respect of the allotments made in favor of the fifth and sixth respondent. It was averred that initially the allotment was made in favor of the fifth respondent on 29th August 2016 without any advertisement having been issued by the corporation inviting offers from interested parties. In the writ petition, the categorical case set up was that the allotment came to be made in favor of the fifth and sixth respondents directly on an application made by the concerned respondents, and despite various objections having been raised to the proposed allotment by the joint managing director, the allotment in favor of the fifth respondent was further sought to be brought under a cloud open the assertion that the initial allotment made in its favor was subsequently surrendered and a fresh allotment made in its favor on 28 September 2016. Insofar as the sixth respondent is concerned, it was alleged that the allotment made in its favor on 22nd December 2016 was not proceeded by the issuance of any advertisement, and the allotment itself came to be finalized by the second respondent by passing the joint managing director a further reading of paragraph 25 onwards of the writ petition carry the allegation of the petitioner against various acts of misfeasance committed by the second respondent. It is alleged in the writ petition that the second respondent was favoring one Anil Verma and that he was indulging in acts which were likely to cause a pecuniary loss to the corporation. The allegations as contained in the writ petition thereafter swayed towards the working and conduct of certain other officers and employees of corporation, the transfers being made by the second respondent. Para. Put in a nutshell, the thrust of the allegations was that the affairs of the corporation were being mismanaged and the second respondent at the helm of its affairs was indulging in acts of nepotism and corruption. Although we have noticed the various allegations leveled in the writ petition in brief, it needs mention at this stage itself that the oral submissions advanced on behalf of the petitioner before us centered and revolved around and upon the allotments made in favor of the fifth and sixth respondents only. Reiterating the allegations leveled in the writ petition, it was asserted by Sri Oza that no policy which countenanced the submission and entertainment of applications directly by interested parties cloud be upheld by the court.